you. Ms. Chambers? Good morning.
Good morning, Your Honor. My name is Sarah Chambers. I'm an assistant bar counsel, and I'm here on behalf of the Bar Council. The issue before this court is whether a public reprimand is a markedly disparate sanction for the respondent's misconduct in this case. We strongly believe that it is, and we are requesting a suspension of 6 months here at a minimum. This case involved an egregious conflict in which the respondent improperly undertook the representation in a personal injury case of Francis Constantino, who was an elderly, hospitalized gentleman with severe injuries sustained in a hit-and-run car accident. The problem arose because the respondent was already representing another client, his first client, Paul Giragosian, in a completely unrelated case, and significantly, the two clients, Mr. Giragosian...
Did anybody along the line here even mention a 6-month suspension? The hearing officer didn't. The appeals panel didn't.
The board recommended a public reprimand, but the 4 members of the board who dissented thought that a 6-month suspension was the appropriate sanction in this case.
Well, my point is you've lost at every stage of the proceedings, including in front of the single justice, correct?
Well, both of us got less than what we asked for from the hearing committee and the single justice in the board. Mr. Carnahan was seeking a dismissal initially and an admonition. We were seeking a greater suspension.
He's now more or less agreed with what the board voted.
That is correct. And we have, changed our request to a 6-month, at a minimum, suspension from an original request of a 2-year suspension.
Well, go ahead.
We think that a 6-month suspension is appropriate here. The problem is that when Mr. Carnahan went to the hospital, he was already representing Mr. Giragosian, and he immediately became involved in the financial dispute between Mr. Carnahan and Mr. Giragosian. When he went to the hospital, he was told by Mr. Giragosian that Mr. Giragosian had received large sums of money from Mr. Constantino, including $20,000 for a down payment on a house. He was also told by Mr. Giragosian that Mr. Constantino's wife was possibly going to sue him to recover this money. He was shown a handwritten document that purported to order the cessation of collection efforts against Mr. Giragosian. So he was on notice that Mr. Giragosian and Mr. Constantino had conflicting financial interests. And critically, 4 days later, after that initial meeting, Mr. Carnahan went back to the hospital with Mr. Giragosian again with 2 documents, a contingent fee agreement and a durable power of attorney. Now, he prepared the durable power of attorney, and he had Mr. Constantino execute it, thereby placing the debtor, Mr. Giragosian, in complete control of the assets and the legal affairs and the financial affairs of the creditor, Mr. Constantino. So this conflict was apparent and egregious at the outset. As the dissenting members of the board pointed out, it was a conflict for Mr. Carnahan, for the respondent, to represent this critically injured elderly gentleman who had expressed conflicting desires over the recovery of money from Mr. Giragosian. There was nothing that this respondent could do that would not violate his duty to his first client, Mr. Giragosian, or his duty to his second client, Mr. Constantino. To serve Mr. Giragosian, he needed to ignore all of the signs of a financial conflict between the two or of undue influence. To serve Mr. Constantino, he absolutely needed to explore all the signs of a financial conflict between the two, or refer Mr. Constantino to independent counsel. He did not do this. This case involves harm, both financial and non-financial. The wife and guardian of Mr. Constantino was forced to engage in all kinds of litigation in Superior Court and in probate court to try to remove Mr. Carnahan from the case. She had to seek clarification from the probate court when she tried to fire Mr. Carnahan because he disputed the validity of the probate order. She had to get an injunction against Mr. Girgosian and Mr. Carnahan. He still refused to withdraw from the case. Mr. Carnahan filed a competing guardianship petition against Mr. Constantino. He went into court on the injunction and represented Mr. Girgosian against Mr. Constantino, and yet said he was representing the interests of both. So there was all kinds of harm, which involved requiring Mrs. Constantino, the guardian, to go into court to litigate against Mr. Carnahan, and also just the cost of preparing the pleadings, appearing in court, was a cost that while Mr. DePaula did not bill the family for, someone incurred that cost. There was certainly a financial cost, but there was also just the non-financial aspect of it, of the causing the family, the guardian, the wife, to engage in needless litigation over and over again. She had to a counterclaim was filed against her by Mr. Carnahan. That is certainly harm. There was also harm in the sense that Mr. Constantino's wishes, we'll never know what they truly were. We'll never know whether or not his wishes were carried out. That's a type of non-financial harm. This court in Wise said that harm encompasses more than merely financial harm or monetary loss, and there was certainly non-financial harm and financial harm in this case. There was also, in Bar Counsel's opinion, self-interest and self-dealing here. There is absolutely nothing wrong with an attorney seeking a contingent fee unless that attorney is conflicted out of the case, as Mr. Carnahan was in this case. The $100,000 insurance settlement was virtually on the table in this case. It was a lucrative and simple $33,000 contingent fee. There would have been absolutely nothing wrong with Mr. Carnahan seeking the case and the fee had he not had a conflict. But he obviously had a conflict. He represented Mr. Girgosian.
What was the nature of that representation?
Mr. Girgosian, he represented him in a motor vehicle repair case. It was a civil dispute, a small dispute, I believe. But he had known him for, I believe it was 15 years. He had represented him, I believe, in another matter, had received referrals from him, and had been on a friendly basis with him.
And how was Girgosian going to benefit from the contingency fee agreement?
It was Mr. Carnahan who was going to benefit from it. Mr. Carnahan was going to receive a $33,000 contingent fee from the personal injury case if he was able to settle that personal injury case of Mr. Constantino's. And the $100,000 policy limit was virtually on the table when he entered the case. So it was a lucrative case, and it was one that he was eager to take given his own personal financial problems. The hearing committee found that influenced his judgment in this matter. The problem is these two cases, the personal injury case, the auto repair case, were unrelated, but the two clients had serious financial adverse interests from one another. And Mr. Carnahan stepped right into it on day 4 by preparing and having Mr. Constantino execute a durable power of attorney, giving the debtor, Girgosian, complete control over the assets of the creditor, Mr. Constantino. He stepped right into their financial dispute. He made any lawyer truly representing purely the interests of Mr. Constantino would have explored his financial wishes and determined what his financial wishes were, like Mr. DePaula did 2 weeks earlier when he met with Mr. Constantino. Mr. Constantino asked Mr. DePaula, I want to talk to you alone about my financial situation. Mr. Garagosian owes me about $100,000. I have loaned him money over the years, and these were not gifts. These were loans. The hearing committee found that. And I want to get this money back. I need $20,000 back right away. Will you take care of that? And those were Mr. DePaula's marching orders. So any lawyer, successor counsel, should have inquired of Mr. Constantino what his wishes were in that regard. I think the important, I think it's important for the court here to order a suspension in this case because of public perception. I think a public reprimand is not enough for a conflict that is this serious. And I also don't think attorney's fees are warranted in this case.
Thank you.
Thank you.
Ms. Chambers. Mr. Leifman?
May it please the Court. My name is Michael Reutman. I'm here representing Dean Carnahan. First, I think it's worth a moment to remind ourselves of the standard of review, very basic. This is a case that was decided by the single justice, Justice Cordy. It was not reported to this court for a decision. He stepped up and made a decision. In cases where in disciplinary cases where the single justice makes the decision, the standard for this court, as announced in the Foley case, is simply to determine whether the decision of the single justice is supported by sufficient evidence, constitutes an abuse of discretion, or is free from an error of law. None of those issues have been argued. Bar counsel does simply not argue, hasn't in her brief and hasn't standing here this morning, argued that Justice Cordy's decision was not supported by the evidence, argued that he abused his discretion in any manner, or argued that he committed some error of law. Really, it's a little hard to see what this court could do other than adopt the decision of Justice Cordy and affirm the public reprimand of Mr. Carnahan. And indeed, after the decision of Justice Cordy, indeed after the decision of the Board of Bar Overseers in a reprimand case, the reprimand is issued. I mean, Mr. Carnahan has already been reprimanded. After the decision of Justice Cordy, the reprimand is again formally issued and at that time is published in Lawyers Weekly. The public has been informed of Mr. Carnahan's reprimand.
Well, the single justice did a good job of distinguishing the various cases that the Bar Council relied on, correct?
Yes.
So, and they lost at every stage of the proceedings, right?
That's correct.
That's about the end of that.
One would think, but then here we are. And I really, all that I can suggest for Mr. Carnahan is that the single justice went through the cases. There are a range of cases dealing with suspension. There are a range of cases dealing with a public reprimand, and there are a range of cases dealing with admonitions. The single justice, but at every step, the hearing committee, the Board of Bar Overseers, and the single justice have looked at that same range and said this one falls in the public reprimand area. Dean Carnahan would have preferred and argued for a private admonition. We no longer take that case. As we say, the bell has been rung. He's been reprimanded. So here we are. And in fact, the one case since the filings of the briefs, your honors may recall that in February of this year, 2007.
Lupo.
Lupo, but also Wainwright. There was a February 2000 decision by this court involving two brothers named Wainwright, another conflict case where this court actually made a decision that there should be a public reprimand. If anything, Wainwright, the misconduct in Wainwright is probably a little bit more egregious or a little bit worse than Mr. Carnahan's, in that the lawyers in Wainwright actually made some money, received fees, were or benefited by their conflicting position. Mr. Carnahan never received a penny on this, and in fact was out the work that he did during the time that the case was his in terms of obtaining medical records and working up the file to establish the contingent fee case. So there's no money that ever went to Mr. Carnahan, not one penny. And I would suggest that his conduct is less worse, slightly better than the Wainwright brothers, and if they were to receive a public reprimand, again, so should he. He is in that range of people. Let me not belabor the point, not keep going. I would make one observation, and that is at the tail end of our brief, we have asked for attorney's fees. A bit unusual, I acknowledge, in a discipline case, but this is a case where the discipline issue was not all that complicated. Once the hearing committee went through all of the issues and decided it, the board went through all the issues and decided the same thing as the hearing committee, that there should be a public reprimand. The case could have ended right there. Public reprimand cases do not need to go further. They do not need to go to a single justice or to this court the way a suspension case or a termination of someone's license does. Case could have ended. Mr. Carnahan would have taken his public reprimand. Instead, we've had an appeal to a single justice who very thoroughly went over the record and decided the same thing, and now an appeal to this court, which we've thoroughly briefed and I would hope would once more look at the same record and decide the same thing. That really is a little unfair to Mr. Carnahan. He has had this hanging over him, this potential for a suspension of his law license, for years now. It also has effects on Mr. Carnahan. For example, he's a quite small practitioner, and he used to do a substantial amount of business off the attorney-lawyer referral panels from Boston Bar and Mass Bar, where attorneys can get referrals of people that call into Mass Bar and say, I need a lawyer. Well, the bar associations will not refer cases to lawyers who have disciplinary proceedings ongoing. It's a good rule, but it means that for all of the time that this is going on, that source of business for Mr. Carnahan is gone.
Do they refer cases when there has been discipline imposed?
I believe if it's an admonition or just a reprimand, they do. You can be back on the panel. I believe that. I'm not completely familiar with that, but that's my understanding.
Then we can't take into account your argument that if there's no evidence that he would have been back on the panel, we can't take that into account.
Granted, Your Honor, I should have followed through on that particular moment. I believe that that is the case, but I don't want to stand here and make a representation that I'm not sure of. It is certainly true that he has been in the situation of having this hang over his head, of having to go through the process of repeatedly briefing an issue that's been decided. And this court has inherent power to award attorney's fees. This whole disciplinary mechanism of attorneys is very much a creature of this court and the rules. And it would have the salutary effect, I believe, of putting bar counsel in the position of knowing if we want to appeal, there's some risk that we're going to have to pay the fees for the other side. That you would not have these multiple appeals of cases that have been thoroughly decided simply on the slim chance that this court is going to find different facts. In this whole argument, we hear you should find different facts on self-dealing, or you should find different facts on harm. That really is quite a long shot to ask this court to go back in and redo the fact-finding that was done at the hearing panel, adopted by the board, and adopted by the single justice. And if bar counsel knew, as prosecutors know under Rule 15 of the criminal rules, that if you're taking an interlocutory appeal of something where the defendant has won, there is some risk that you will have to pay attorney's fees if the appellate court again affirms that win for the defendant. And I suggest to Your Honors that you would not be hearing this case, and you would not hear the next somewhat slim discipline case if bar counsel had to make a second thought about, should I appeal because I may need to pay the attorney's fees for this defendant. Thank you very much.
Thank you, Mr. Whiteman.